North Carolina legislators are looking to ratify the Equal Rights Amendment. Dr. Karen Zip, a women's history professor from ECU, says this has been a legislative battle for nearly a century.
Alice Paul wrote the original Equal Rights Amendment, which is basically the exact same thing that you see here. She wrote it in the 1920s, and it has gone forward to Congress since then.
It was rejected in Congress for about 50 years until the 1970s.
So in 1972, especially with the push for bringing women more rights in the workplace, Congress passed the Equal Rights Amendment.
Progressives advocated for the Equal Rights Amendment even after the 1964 Civil Rights Act was passed. The Civil Rights Act ended segregation and made it illegal to discriminate a person based on their race and a variety of other factors, including gender. But that act can be fought in the legal system.
And while there are Supreme Court cases that uphold the 1964 Act, who's to say what the Supreme Court would decide if that act should be, for some reason, undermined?
Ratifying the Equal Rights Amendment would make it unconstitutional to discriminate between men and women. Zip tells us how that could look like.
It could have effect on women in the military. It will certainly accelerate women's opportunities in the military and family leave policies. So like, for example, giving women more time for maternity leave will be considered, than men would be considered unconstitutional.
The Supreme Court will ultimately decide whether or not to add the Equal Rights Amendment to the Constitution. There are many challenges the ERE faces, but Zip says the biggest one is time.
Then Congress at one point put on a time period. They didn't want this. This was not, this is sort of a little bit more arbitrary than it sounds, that we have to have a time period on our amendments ratification. And that time period was scheduled to elapse in 1982, as that bill says. And when the time period elapsed, Congress took up the issue of the ERA again.
The second time around, they rejected the ERA, but last year, Virginia became the 38th state to ratify the amendment. This brings it to the Supreme Court to be decided in a legal battle. Zip says if North Carolina ratifies the amendment, it shows strength in the Supreme Court case, since North Carolina originally rejected it.
Whether North Carolina passes this amendment or not, or ratifies this amendment, doesn't matter, because Virginia has ratified the amendment, and that amendment has received the number of states required for ratification. It's just that it's all without this time period. So North Carolina would be sort of like icing on the cake.
Besides the Supreme Court battle, the ERA is also facing challenges from the left and the right because of its stated language. The language in the bill says men and women and does not include other genders. Language in bills cannot be changed once a state ratifies them. Zip says North Carolina's legislative history with the ERA can give her an idea of what will happen in the General Assembly.
So I think that North Carolina will probably be, first of all, generally negative about ratifying anything about this. And if there is momentum, it's going to be kind of chaotic momentum.
In Greenville, Victoria Holmes, 9 on your side.